Alright guys, now we continue with court with special jurisdictions. We start with court for children. This is also known as juvenile court. Its establishments, it was established under Part 4 of the Child Act 2001. The purpose of having this court for children is to hear, determine or dispose any charge against child. Based on Section 2 of the Child Act 2001 defines a child as a person under the age of 18. Why we have to charge children, okay, when they committed an offense? Okay, what is the rationale of having this court for children? I give you one illustration. Let's say Ali committed crime at the age of 17 years old. So at that time, he was still a minor, considered as a child. He was charged a year later. After 1 year later, he was charged, meaning at the age of 18 years old. So, which court should have jurisdictions against this matter? The High Court. The answer is High Court. Okay, because he was charged, okay, at the age of 18 years old, so he is not considered as a minor. Okay, so what is the rationale of having this? Okay, why we need to charge Ali? Okay, this is based on the case of public prosecutor against Muhammad Tirmizi Mahazir, okay, in a 2007 case. The principle held that they must be, they here refer to children must be held responsible for what they have done. Alright, so age is not a matter. Okay, so age is no excuse for the court to charge children, okay, when they committed offense. Okay, so back to the compositions of courts for children. Okay, there should be one first-class magistrate, be assisted by 2 advisors. One of the advisors must be a woman. Okay, and the advisors' functions are to inform and advise the court on any consideration affecting the order made upon a finding of guilt or other related treatment of a child brought before it, and to advise the parent or guardian of the child if necessary. Okay, so meaning that we have the advisors here in order to advise if there is a dispute arises later. Okay, next, jurisdictions of court for children. The court has jurisdiction to try all offences punishable except offences punishable with death penalty. Because for death penalty, for example, offence like a murder, okay, the case will be heard before the High Court, not the court for children, because the court for children has no jurisdiction to hear the case in light of Section 97 of the Child Act 2001. If the child offender is found guilty, he will be detained in a prison under such conditions as the YDPA or Yang di-Pertuan Negeri may direct. Okay, for punishment, sentencing released by this court, the court may pass the following punishments, which include to admonish, to admonish and discharge the child. Okay, admonish here means to give a warning, to reprimand firmly the child. Probation order, the child will be placed under the supervision of a probation officer for a specified period. In other words, dalam pemantauan. Okay, or he will be sent to Henry Gurney School. If the offence committed is very serious, the child will be sent to this school for a period of 3 years or until he reaches the age of 21. Okay, for the serious offences, for example, like kidnapping, rape. Okay, a proceeding. Okay, proceeding. Privacy of the proceeding is ensured. Okay, if practicable, the session shall be held in a different room or on different days from those on which sittings of the courts are held. So the proceeding is not open to public. Okay, those who can attend the hearing is limited to members and officers of the court, the children who are the parties to the case, the parents or guardian of the child, the concerned lawyers, the witnesses, and other people determined and allowed by the court. Okay, media reporting is also restricted, cannot disclose name, address, pictures, or any information that may lead to the identifications of the child. They may highlight the offences, the hearing, but they cannot disclose the personal informations of the accused child. Okay, so the purpose here is to protect the interests of the child. Okay, even he committed an offense, committed a crime. Okay, but since he is still a minor, so we need to protect and safeguard, okay, the interests of the child. Okay, next we have a special court for rulers. Okay, and this court was introduced in 1993. Before its establishment, the rulers were immune from being tried in any court proceeding. Okay, in terms of its establishments, established under Article 182 of the Federal Constitutions, Part 15 of the Federal Constitution's compositions. Okay, Chief Justice of the Federal Court, and then Chief Judge of the High Court of Malaya, Chief Judge of the High Court of Sabah Sarawak, and then 2 other judges either from Federal Court or the High Court. Okay. Jurisdictions of this court is to hear and try civil and criminal case brought against the YDPA and the ruler of a state in their personal capacity. Okay, not in his official capacity. Okay, any civil or criminal action against YDPA may only commence after obtaining the Attorney General consent. So this is the condition required in order to hear any dispute against YDPA. Okay, example of case brought to the special courts jurisdictions. In the case of Faridah Begum binti Abdullah against Sultan Haji Ahmad Shah, Sultan Pahang. This was a defamation suit brought by Faridah Begum, a Singaporean businesswoman, against Sultan Haji Ahmad Shah. The AG consented, because this is a condition to hear the dispute, allowing the special court to hear the case, and the court interpreted Article 155, 181 and 182 and 183 of the Federal Constitutions and held that the right to sue the ruler belonged only to Malaysian citizens. Since Faridah Begum was a Singaporean, she can't bring the action against Sultan Haji Ahmad Shah. So the rights only given to Malaysian citizens to bring the case against the Malaysian rulers, including the YDPA. Okay, next we have a court martial. Okay, court martial was established under Armed Forces at 1972. Okay, this is a special for Army, Navy, okay, Air Force. Okay, in terms of its compositions, qualified officers to hear cases. Okay, they don't need any judge there. Okay, so Chief Officer of the Armed Forces Staff, Chief of the Army, Chief of the Navy, Chief of the Air Force, any officer not below the rank of colonel or its equivalents. The jurisdictions of court martial here is to hear dispute, okay, regarding armed forces, including Army, Navy, and Air Force. And it has the jurisdictions to try any person subject to service law for offences triable by court martial. Okay, the example of offences, okay, here by a court martial here, when there is a case of aiding the enemy, okay, helping the enemy, communication with the enemy, offences against moral, okay, looting here means that if they steal goods during a riot or war. Okay, mutiny and subordinations. Okay, mutiny means rebellions against authorities. Okay, using a weapon. Okay, and then avoidance or failure to perform military duties. Sentences also can be released by this court. Punishments include death, imprisonment, dismissal with disgrace, forfeiture of seniority of rank, fine, or reprimand. Okay, by giving our warning. Okay, that's all about court martial. Okay, next we continue with native courts.